Moving to item number 5, and I think Mr. Hickman, the in-house, very dapper-looking lawyer up here, is going to speak to this agenda item. Mr. Hickman, welcome, sir.
Thank you, Your Worship. For those of you that don't know me, my name is Stuart Hickman. I'm the Councillor Council. My job today is to give you an overview of certain laws which affect you in your capacity as members, and I've set out in my report laws which are required to bring to your attention at this first meeting. Now, what I intend to do today is just give you a high-level heads-up overview of those laws, and note that we will be covering legal issues and laws, including the Local Government Act, in greater detail at a workshop which is coming up on the 2nd of November. So there may be questions which come out of my report. It may be the case that the best time to ask those is at the workshop, or in the meantime, I'm free between then and now if there are any other questions, so please feel free to contact me. So moving on, the first statute that I'll be discussing is the Local Government Official Information and Meetings Act 1987. Now, there are two aspects to that act. The first concerns access to information which is held by council, and the second concerns the conduct of meetings by council. Under the Act, most information that Council holds is to be made publicly available upon request. Now, that information can include agendas, reports, letters, emails, and that could be emails amongst yourselves as councillors using council laptops. Council can only refuse to provide that information where certain exceptions in the Act apply. A couple of those which we commonly use would be in the case of legal privilege for legal advice, or where the information is commercially sensitive. Turning to meetings, Council can exclude members of the public from meetings, again where certain criteria in the Act are met. Common examples are where Council is discussing legal advice or commercially sensitive information. I'll turn to the Local Authorities Members' Interest Act 1962. Now, the Act establishes rules designed to prevent conflict between elected members, between the elected members' personal financial interests and their official duties. So there's two aspects to the Act, which I've set out here. The first controls the making of contracts worth more than $25,000, including GST, in any financial year between elected members and council, which is known as the disqualification rule. And the second part of the Act prevents elected members from voting on or discussing matters in which they may have a financial interest, which is known as the financial interest rule. Now, you would have received hopefully a copy of a good practice guide which has been published by the Controller and Auditor General. Now, this is called Guidance for Members of Local Authorities about the law and conflicts of interest. And the guide really does provide an excellent summary of the law, not just in relation to financial conflicts of interest, but non-financial conflicts of interest also. Now, the effect of the disqualification or contracting rule is that an elected member is disqualified from holding office if they are concerned or interested in contracts with council under which the total payments made or to be made exceed $25,000, including GST, in any financial year. Now, it's an offence against the Act to act as a member of council while disqualified. However, the Auditor General can grant dispensation or prior approval and in limited cases retrospective approval in relation to a member's interest in a contract. And the effect of that approval has the effect of which is to suspend the disqualification rule from acting in any particular case. One particular point to note is that the rules may apply to members through their spouses, civil union partners or de facto partners, or through shareholdings in companies that contract with council. I'll turn briefly to the financial interest rule. Now, that rule provides that an elected member can't vote on or take part in a discussion of a matter before council in which they have a financial interest. And that's an interest other than an interest which is shared in common with the rest of the public. Again, under the Act, certain exceptions apply. When the matter is raised at a meeting, elected members have to declare that interest and the minutes must record that fact. Again, it's an offence for a member to breach the provision, and if convicted, they would automatically vacate office. Again, the Auditor General can grant an exemption or in a limited range of situations, which allows a member to participate in the matter. Again, it's a little peculiarity of the Act that in some cases an association with a company or a partner may trigger the rule as well. I'll turn now to the Crimes Act 1961, and I've set out in my report sections 105 and 105A of the Crimes Act, which deal with bribery and corruption. Section 105 of the Act deals with bribery. Put simply, it's an offence against this section to seek or obtain a reward for performing one's official duties as a councillor. Under 105A, it's a crime for an elected member to corruptly use or disclose information obtained in the course of their official capacity to obtain an advantage or pecuniary benefit. And the consequences I've set out in my report of a conviction for either of these offences is significant. Turning to Secret Commissions Act 1910. This Act deems every councillor to be an agent of council, and it creates a number of offences, including in relation to accepting inducements or rewards for doing or not doing something in relation to council affairs. It is also an offence under this Act for a member not to disclose to the council his or her financial interest in a contract entered into on behalf of the council. So I've set out there, under those bullet points, the offences created by that Act. Turning to the Securities Act 1978. The reason this is included is because council has wide borrowing powers under the Local Government Act 2002, and one of the ways that council can borrow is by issuing stock or other forms of debt instruments. Now, if those instruments are offered to the public, council has to comply with the Securities Act. That Act regulates the offering of securities to the public, and local authority debt instruments are securities for the purposes of the Act. Now, if council chooses to offer debt instruments to the public, it has to produce a prospectus and an investment statement which complies with the Act and any regulations. As well, any advertisements relating to the offer have to comply. Certificates would have to be issued to investors, and certain information relating to council and the securities would have to be sent to the holders of council securities. As I've noted in my report, this is a very complex area of the law. That's certainly something I have never come across in my time here at council, and certainly specialist advice would be required before the issue of securities. I would note, however, that elected members are deemed to be directors of council for the purposes of the Act, and as such councillors would remain potentially personally liable to investors if a registered prospectus or an investment statement contained an untrue statement. I'll touch briefly on members' indemnity, which I've set out in paragraph 8 of my report. Generally speaking, councillors are indemnified in respect of their actions as a councillor, and the Local Government Act provides for that indemnity in relation to civil liability, where a councillor is acting in good faith, and also in relation to costs arising from a successfully defended criminal action, which relate to acts or omissions in his or her capacity, in a councillor's capacity. There is a theoretical personal exposure on the part of councillors in certain circumstances, and I've set that out in my report, and that's where the Auditor General has reported on a loss which has been incurred by council, and a loss for which council has not been compensated. And as I note, the loss must arise in certain circumstances which I've set out in my report. Finally, I just want a couple of further points just to briefly touch on one matter which isn't addressed in my report, and that concerns council's code of conduct. The Local Government Act requires council to have a code of conduct for councillors, and that code of conduct sets out the understandings and expectations about the manner in which councillors may conduct themselves while acting as councillors, including behaviour toward one another, staff and the public. And under the Act, councillors must comply with the code of conduct. If you haven't had copies, we can get you copies of that as well. Your Worship, thank you, Your Worship. As I say, pretty heavy stuff. I am available to take questions afterwards if you wish. question. What was said to me before, Your Worship?
Well, as I said to you before, Mr. Hickman, we're preparing for the meeting today, and I'll say it to all the councillors here, if you're not sure, knock on the door. Mr. Hickman's door is always open, so if you're not sure, knock on the door. But look, at the end of the day, there's a lot of acts you have to work under and be conscious of, and they sit above your head like a big black cloud, for want of a better word, but they're not black clouds. You just have to act like decent, civilised citizens, make sure that your conscience is always clear. You do not involve your business in council business. If your business, for whatever way, is involved in any way, shape or form, get the hell out of the chamber while that business is going on, so you don't set yourself up for ridicule. People like to ridicule, it's very easy, and you are moving targets, or you're actually a stationary target for a lot of people. So just, if you're not sure, knock on the door and ask Mr. Hickman or Mr. Williams or myself, but I'm sure nobody needs to ask. And on top of that, with standing orders, I have no objection to people saying whatever they want to say to the media. If it is not what council has decided, be very explicit to say, this is my opinion, however, I go with the majority. That was a democratic decision. However, I believe something else. But speak for yourself, not on behalf of council, because once a decision's made, you must go along with it. That's simple. But I have no problem with people wanting to say what they want to say, provided they pay respect to everybody else that's on the council and council itself. So Mr. Hickman's a very friendly, easy guy to get on with, as I'm just repeating myself. If you're not sure, knock on the door. A very easy policy to follow, and take the advice, heed it well. So, Mr. Hickman, thank you very much for that. There's a suggested resolution that the information be received. I'd like a mover, please. Move, Councillor Hickling. Second, Councillor Johnson. All those in favour? All right. Now, we did make a small mistake today. I guess we're all a little bit nervous, and I'm really, really pleased to see this, but I keep talking about being district councillors and trying to be as least parochial as we can. Our new member, Councillor Kirsty Truman here, Mangakino School, extremely proud of their new young councillor. They were going to do a waiata after agenda item number 3, and we skipped it. So before we go to agenda item number 6, you're more than welcome to come forward and perform the waiata. And it's the Mangakino School, Kirsty?
Yeah, Mangakino Area School.
Yeah. So we're going to have a small waiata. You might want to turn around and face that way when you do it, because it'll be on webcam. Again, apologies we didn't do that at the correct time, but we're not perfect and we got it right at long last. So thank you, Mangakino School. Thank you, Kirsty, of Miss Councillor Truman. Actually, it's been pointed out to me by the Chief Executive Officer, when you put standing orders to one side, you can actually call people by their first name if they so wish. You're no different to a board of trustees or board of directors. That's the job we're here to do. So, yeah, just as an aside. So thank you very much, Mangakino School.